Hi Internet, here's my Matchbox disclaimer. I'm not your attorney unless you have a signed contract with my law firm and you've paid the applicable fees. This video is not legal advice and is for informational purposes only. So today, I want to talk about communication, and communication in the sense that when you're in the middle of litigation, it just comes up over and over and over again. And if you're wondering what do I mean by communication, let's talk about this. First, there's communication between a client and their lawyer. Those communications are only intended to be seen between the client and their lawyer. But sometimes a client needs help with a family member or friend in navigating their case. So they'll have a family member or friend reach out to their attorney. It's so important for people to understand that if a third party is talking to their lawyer, so a third party would be an example of that friend or family member, that those communications, they're not confidential. So what does that mean in the real world? It means that if the other party in the lawsuit knows that a family member or friend talked to your attorney, that person can have the family member or friend provide all of the details of the communications that they had with their client. And a good example of this is really with email. So if you're a client and then you copy a friend or a family member, or if you forward an email from your attorney to a family member or friend, that family member or friend could later have to turn over those communications, and they could involve strategy or private conversations between a client and their attorney. Another kind of more public example of how communication is important to understand during litigation would be the Alex Jones trial. And if y'all remember, during that trial, Alex Jones's attorney turned over all of his client text messages, including messages that were criminal incriminating against Alex Jones and some other people. And it appeared that his attorney did not review the messages prior to sending them to opposing counsel. So this is what makes it interesting to me. I have a duty to my client, but I also have a duty to follow the legal rules and state bar rules and the rules of ethics and conduct. So in a case, if discovery is served, and just a side note, if you don't know what discovery is, it's when you get questions or you get a request for documents. So if you have a case where discovery is legally served on the client, I, as an attorney, I have an ethical duty to make sure that my client responds in full. I also have an ethical duty to make sure that if there's incriminating information in the discovery responses, that number one, I'm aware of all the incriminating information, and two, I've advised my client as to the best way to proceed when responding to discovery. And sometimes that involves in getting a criminal defense attorney to provide me and my client advice. I also have a duty to make sure that I don't turn over privileged communications between myself and my client to the other attorney. I'm sure that I'll have a lot of other thoughts on communication at the time, in the future, but for today, these were kind of my notes on this issue. I hope that everybody is having a good morning and have a good day, and bye.